Welcome, everyone, to the third annual LogiCal-LA conference. So let's be clear about what this conference is about, and what exactly is scientific skepticism. Briefly stated by Paul Kurtz, one of the giants of scientific skepticism, a skeptic is one who is willing to question any claim to truth, asking for clarity in definition, consistency and logic, and adequacy of evidence. The use of skepticism is thus an essential part of objective scientific inquiry and the search for reliable knowledge. Carl Sagan said, "Science is a way of skeptically interrogating the universe with a fine understanding of human fallibility. If we are not able to ask skeptical questions, to interrogate those who tell us that something is true, to be skeptical of those of authority, then we're up for grabs for the next charlatan, political or religious, who comes ambling along." At the heart of this movement is the quest for truth using scientific inquiry. With so much pseudoscience, we need a methodology that can be used to tell us not if a claim is 100% true, but to examine if a claim is most likely true. In other words, to provisionally believe a claim is true until more compelling evidence is presented. Science and scientific research can and will improve our understanding of social issues as well. But there is one issue that is overriding all of these issues. It's climate change. We are placing the human race in a precarious position for future generations as we ignore the prognosis of the world as a whole. As the SGU, Skeptics Guide to the Universe, said several weeks ago on one of their podcasts, this generation is the one who must start to change our planet. It will be much more difficult for the future generations to make a significant change without doubling or tripling the cost to make that change. And most of the current world issues will diminish because all efforts will be placed on saving our planet. We should help other carbon-intensive countries change to a carbon-neutral energy sources. We hope you enjoy the stimulating lectures that our speakers have to offer.
Our next speaker is going to talk to us, but we're going to do one of her trivia questions. So get your flags ready. Are you ready? Okay. Incarcerated parents are more likely to lose custody of their child than parents who have physically or sexually abused their child. Let's see the true flags first. I'm not even going to look. Someone else can look at that. And then, okay, so that's the true. And now, how about the false? Yeah, it's true, folks. It is true. Yeah. And to talk about the very subject is somebody who's a lawyer, so be careful, you know. So Lakeshia Dorsey is going to come up and talk to us about this. And I would like to bring her up with a warm round of applause. Welcome up, Lakeshia. Have fun, okay? See ya.
Good morning. I'm excited to be here with you all today talking about two areas of law that are very, very important to me, which include juvenile dependency law and criminal law. I have another trivia question that I want to do and take a point of privilege really quick. If you have your flags, raise your flag if you consider yourself to be a critical thinker. The blue flag, sorry. All right. Now everybody close your eyes. Don't keep your flags raised. Keep your flags raised. Everybody close your eyes, because I don't want to shame anybody. If you have your flag raised, you think that you're a critical thinker, but you do not answer your jury summons, you throw it away, or you find every way to get out of jury duty, put your flag down. Okay. It's really important for us all to do jury duty, so I just wanted to just kind of plug that in there. Juries are probably one of the most important elements of our criminal justice or injustice system, however you want to say that. So our presentation today is about the Adoptions and Safe Families Act. The Adoptions and Safe Families Act, just for framework, was legislation passed by Congress in 1997 essentially establishing timelines for reunification for the first time in the child welfare context. So basically, when a parent loses custody of their child, or CPS or DCFS removes a child from a parent's custody, prior to the Adoptions and Safe Families Act, there were no timelines. So children were essentially staying in foster care for long periods of time. And so the Adoptions and Safe Families Act established timelines, which essentially says if you have a child removed from you, you have 15 months out of 22-month period to have your children returned back to your care and your custody. And if you do not have your children returned in that period of time, then states are required to initiate proceedings to terminate parental rights. So that's kind of the framework that we're starting from. I'm going to go ahead and dive right in to the presentation because I only have 30 minutes. My 30 minutes start now. I'm just kidding. Okay. So I want to talk to you guys all about one of my clients. So Kiana was approximately 17 years old when she gave birth to a beautiful baby boy named Aiden. And when Aiden was 7 months old, his father was tragically killed in a drive-by shooting, leaving Kiana as a struggling single mom trying to raise her son. She began resorting to things like shoplifting and petty theft to be able to support herself and her child. And when Aiden was approximately 3 years old, she went into a Target store. She stole a pack of Hanes underwear, she stole a bra, and she stole some eyeshadow, put those items into her purse, and attempted to leave the store. And as she was leaving the store, she was confronted by security. Security and her, they got into like kind of a struggle. She was trying to pull her purse away so that she could leave. And she told me that the one thing on her mind was, I cannot get arrested today because I have to pick up my son from preschool. Long story short, she ended up getting detained. She ended up getting arrested. She went to jail. She didn't have any money to bail out, and she didn't have any numbers memorized to be able to call anyone and let them know where she was at. Aiden didn't get picked up from school that day. DCFS got involved, removed Aiden. He ended up in the foster care system. Meanwhile, as Aiden's case is going on in the juvenile dependency court, Kiana pleads guilty to 1 count of felony robbery in state court, and she's sentenced to the low term of 2 years in custody. Oh, sorry. So during the course of this case, so approximately a year into Aiden's case, I had to contact Kiana and let her know that the court was initiating proceedings to terminate her parental rights. Kiana was permitted to come to that hearing. Aiden was super excited to see his mom. He hadn't seen her since the first initial hearing in the case. And that was the last day that he was able to see my client because he ended up becoming adopted as Kiana's parental rights were terminated. And in California, we have a closed adoption system. What's a closed adoption system? Essentially, once you're adopted, parents can know, but there's no more communication, no more contact, right? So there are 2.7 million children in the United States like Aiden. 2.7 million children in the United States who have a parent that is incarcerated. And these 2.7 million children are the children of 1.2 million parents. Now, fortunately, a majority of incarcerated parents' children reside with a grandparent or other relative, but approximately 15 to 20% are in the foster care system. And post the Adoptions and Safe Families Act, because we have these timelines, these statutory timelines that have been established that states implement, when you have a situation where you have a parent that's incarcerated and a child in the foster care system, 9 times out of 10, that situation is going to result in a death sentence for that family, because the average sentence for parents in custody is 2.6 years. So I want to talk about how California, so the Adoptions and Safe Families Act allows for states essentially to implement the requirements of the federal legislation. So since we're in California, I'm going to talk about California law specifically and how California has implemented the Adoptions and Safe Families Act. So in California, there's no go to jail, lose your child rule. That's what it says. That's what the law says. In practicality, however, it typically, again, results in termination of parental rights because there's so many barriers to reunification once you have a parent that's incarcerated. So in California, essentially the law says if you can make an appropriate plan for your child, if you can get that child with a family member, the grandparent, with another parent, maybe that's not incarcerated, then we will not take your kids. We're not allowed to take your kids. However, for those who are familiar with the law in any way, shape, or form, our laws are typically very ambiguous. So there's no definition for what an appropriate plan means. Everyone has a subjective, interpretation of what that means. So you might have one social worker that says, I think that this is an appropriate plan, and a judge agree with that. Or you might have a social worker with that same plan that says, I don't think this is an appropriate plan. And have a situation where the judge says, okay, I'm going to take jurisdiction of this case because I don't believe that the plan is appropriate. Also, although the Adoptions and Safe Families Act says that you have 15 months essentially to have the child return to the custody of the parent before proceedings are initiated to terminate parental rights, California's interpretation of the Adoptions and Safe Families Act is actually more strict. So in California, if you have a child that's 3 or younger, you have 6 months to demonstrate to the court that you're able to have that child return to your custody and care, and the child would be safe. If the child's over the age of 3 years, then you have 12 months to make that showing to the court. As you can imagine, given the fact that the average sentence for a parent is 2.6 years, well beyond those timelines, that is a very difficult task to occur. Additionally, there are other barriers to reunification, which include bypass. And we'll talk a little bit more about bypass, but essentially, the Adoptions and Safe Families Act allows states to implement laws that say, you will not get reunification services, we're not gonna waste court time, we're not gonna waste taxpayer dollars, we're going to deny you services to reunify, and by the way, you have to have reunification services in California in order to reunify with the child. We're gonna deny those services, and we're gonna go straight to a termination of parental rights hearing. And so that's one barrier that some parents have that are incarcerated. Also, as far as reunification services are concerned, the other barriers could be in the parent's ability to complete a case plan that is ordered by the court, or their ability to be able to visit their child. So first, talking about bypass. So incarcerated parents are at a higher risk of being bypassed. Again, in California, there's no go to jail, lose your child rule. And reunification services, the law says, must be provided to an incarcerated parent unless the court finds by clear and convincing evidence that services would be detrimental to the child. Well, the factors that the court looks at in making that determination include the age of the child, the degree of the parent-child bonding, the nature of the parent's crime, the length of their sentence, potential detriment to the child if services are not offered, and then the views of the child if they are 10 years or older. Well, for parents who are incarcerated, if they have a sentence that's longer than the statutory timeline, sometimes that factor in and of itself trumps all these other factors, and the court says, you know what, again, we're not gonna waste taxpayer dollars, we're not gonna have this child, languishing in the foster care system, we are going to immediately set this matter for a termination of parental rights hearing, and try to get this child into, stable, into a stable family. Another, risk of bypass is, again, per the Adoptions and Safe Families Act, it permits states to implement, sections within the code to terminate parental rights as well. So what California law says is that if you have a parent that's convicted of a violent felony, and the court finds this to be true by clear and convincing evidence, then the court cannot order reunification services to that family unless the court finds by clear and convincing evidence that it would be in the child's best interest. So I want to talk about some of the crimes, I guess, that are defined as violent and felony and that are listed in the Welfare and Institutions Code 361.5C. So I heard some of you earlier, you guys heard about the story I talked to you about my client Kiana, right? And the fact that she was convicted of robbery, right? You guys all heard the facts, right? Our typical, when we think about robbery, we think of someone bringing a gun or a knife or making some type of threat, right? We think it's something serious, some type of serious conduct that's happened. Well, in California, all of the crimes that I have listed here that require bypass by the court, there's a wide range of conduct that can fit within those particular statutes. So robbery, for example. In California, there's a case called People v. Estes. And essentially what the court in that case found is that any amount of force that's used in the commission of a theft constitutes a robbery. So in this case, in Kiana's case, what constituted the robbery was the fact that she had the items that she stole in her purse and used force to pull her purse away. Okay, that's why it became a robbery. And for a robbery in California, the low term is 2 years, and midterm is 3, and the high term is 5 years that you would get on the sentence. The court can give probation. I think because my client had so many shoplifting, petty thefts, and things like that, they didn't want to give her a break. But in that case, they gave her 2 years. Okay, again, well beyond the timeline, the requirements of the Adoptions and Safe Families Act. Because of my time, I'm not going to go into those other crimes that I have listed here, but the same thing is true with those crimes. There's a broad range of conduct that can constitute a kidnapping that you'd be like, wait, that's a kidnapping? And a broad range of conduct that can constitute a first-degree residential burglary, and you might look at it, as a layperson and not think that that would be considered a first-degree residential burglary. So other barriers to reunification for incarcerated parents is if the court does say, okay, we're not going to bypass, we are going to give your client reunification services. So in Kiana's case, the court did do that. I was able to talk to her public defender, and I was able to get the case in the juvenile court, get her services before she got sentenced. And so essentially what I did was tell the court what the conduct was in the criminal case, and the court was like, okay, we'll give her a shot. And so the court did order services. The services typically, there's 2 components. It's a case plan and visitation. So for incarcerated parents, they are at a disadvantage because courts order them typically to do, parents who lose their children, to do a wide range of services. It could be individual therapy, it could be parenting. If there's any indication that there's drinking, even though people may drink on a normal basis, they may order them to do some type of drug treatment or alcohol treatment. But for anyone who's familiar with our penal systems here in the United States, programming in prisons and state prisons and local jails is being slashed left and right. So incarcerated parents may not even have access to the programs that the court is ordering them to complete. And where there is programs, let's say they are lucky and they get into a institution where there is programming available, oftentimes there's a wait list because everybody else is also trying to get into those programs. Our clients that we represent in criminal court are usually trying to get into programs so that they can ask the court to reduce their sentences, right? But in spite of that, the clock keeps ticking. It's not like the clock pauses because our clients that are incarcerated and have a child in the foster care system, it doesn't pause for them to be able to, get onto the wait list, and then now we'll pick back up the time. The clock is ticking that entire time once that child is removed. Also, as far as visitation is concerned, it's difficult for incarcerated parents to be able to visit their children. I would say of the 2 components of a case plan, visitation for parents who have their children taken by the Department of Children and Family Services, visitation is the most critical. Because by the time a case like just procedurally gets to the point where there's a proceeding for termination of parental rights, the only question that the court is asking is the child adoptable? They're asking, is this child severely developmentally or mentally disabled such that maybe they won't be able to be adopted? But they're not asking, did the parent finally get it together? They're not asking, would the child be safe? Those are not questions that can be brought up at a termination of parental rights hearing. The one exception that's relevant, I think, for parents that are incarcerated would be for them to be able to show that their relationship with their child is so beneficial that it outweighs the benefit that their child would receive if they were adopted or placed in like a guardianship or something more stable. So visitation, I think, is the most critical of these two things. You could theoretically only visit your child and never do the case plan and be able to make that showing. And I have seen parents do that are not incarcerated. But for incarcerated parents, visitation is a challenge and it's a barrier because while the court cannot say, because you were incarcerated, we're not going to order visitation, they still can, again, this whole exception, there's always exceptions to everything. If they find that there would be detriment to visitation, then they don't have to order it. And for individuals who are incarcerated in federal custody or in out-of-state custody, then the court does not have to order visitation for those parents. So the only parents who actually, I guess this would protect are parents in local custody or parents that are in state custody. So in some instances, especially if you have a child that is really young, so like 5 years or younger, the court will say that in and of itself is enough for me to find detriment to visitation. We don't want this 5-year-old going and seeing their parent in custody or being in the elements, I guess, of a incarceral penal system. And that it makes sense to some degree, but that is a barrier. Also, just location, visitation, penal institutions are far typically. And what they say, like I think it's over 60% of prisoners that are assigned to prisons are more than 100 miles away from where the child lives, okay? And so a lot of this, I think sometimes it's because the courts will order for there not to be visitation because of the practicality of things, right? A social worker isn't gonna recommend for a visitation to occur if they're gonna be the ones that are gonna have to travel 100 miles to take the child to go do a visitation and wait in those long lines to be able to, have the child visit that parent. And so unless the child is with like a relative or something like that, the visitation usually doesn't happen for parents, for children who are incarcerated. Children who have parents who are incarcerated. So one of the things that we do as attorneys when we're talking to our clients about this visitation piece is we'll, advise them to do something like call as often and as frequently as you can. At least I can go to the court and say, Your Honor, they've done everything that they can to try to keep a relationship with their child while they've been in custody. Well, again, another barrier though is sometimes the cost of calling is prohibitively costly. And they don't have the funding or the ability to be able to call on a consistent basis. Also, another challenge for individuals who are incarcerated is the visitation, if it does occur, is probably not going to be as meaningful as a situation where you have a parent that's out of custody. So parents who are out of custody, they typically are permitted to visit at least one time per week for 1 to 2 hours. I still don't think that's enough, but at least they have that. But for an incarcerated parent, I think that a social worker is going to be like, yes, every week I'm going to make a trip to go somewhere to facilitate visitation. It doesn't happen. And then the visitation isn't meaningful, right? Because there's no contact that can happen, right? There's no contact between the parent and the child that can occur. So it's, not meaningful. And so because of those two components, those parents face, because of all of these barriers, it is very unlikely for a parent who's in custody and has a child in the foster care system to be able to reunify with their child. The study showed between 90 to 92% of incarcerated parents, where there's just one parent incarcerated, have their parental rights terminated in the United States. And for children, for situations where both parents are in custody, it is 100% in those cases where parental rights are terminated. And as we talked about in our trivia question, mothers and fathers who have a child placed in the foster care because they're incarcerated, not because they, abused their child, neglected their child, or been found to, have physically or sexually assaulted their child, are more likely to have their parental rights terminated than a parent who is found to do those other things. So I want to talk about solutions. So in California, and that's why I said for the most part, some states have crafted ways in which to get around, termination of parental rights. California, we have what is called a 388 petition. So children who've been in the foster care system for a long period of time can file a 388 petition with the judge and say, I've been in foster care for a long time, and I want to have reunification services reinstated to my parent, even though parental rights were terminated. But in those cases, first the child has to know about that right. They have to find out or navigate their way to someone that is going to assist them with filing that motion. And then their attorney has to be on board as well, because in California, children's attorneys serve two roles. They are their attorney, but they're also their guardian ad litem. So they have to tell the court what their client wants, but they also have to tell the court what they believe is in the child's interest. And I've never seen a case where an attorney who was arguing for parental rights to be terminated to turn around and then say, yeah, I think it's a good idea for mom or dad's rights to be reinstated. So in practicality, while that avenue exists in the law, it very rarely is utilized. Another solution may be to extend timelines for parents. So I talked about at the beginning of the presentation that as far as the average amount of time that parents who were incarcerated are in custody is 2.6 years, okay? Even me, who's like super big advocate about families staying together whenever possible, I understand like if a parent is incarcerated for 10 years, maybe even 5 years or 20 years, a majority of a child's life, that you may need to find some stable situation for that child, right? And not have that child just sitting in the foster care system. But if you have a situation where a parent's in custody for 2.6 years or less, even closer, I guess, to that 15, like my client, 2 years, right? They may be extending the timeline for those parents, right? When the basis for their child, they've already had suffered the consequence of doing the time for the crime that they committed. And then to have the collateral consequence of having their entire family shattered, I just think that is not just. Also, in terms of another solution that I think juries are, again, one of the most important aspects of our just legal system in general. And so the reason why I brought up jury trials is because in civil cases, there's a lot of civil cases that are being brought forth where attorneys are essentially arguing that parents who were went through the dependency process, due process rights were violated. And juries are literally awarding like $1 million verdicts saying, yes, I agree that this parent's rights were violated, their constitutional right to associate and have care and custody of their child. Well, even after a parent gets that verdict, they can't go into juvenile court and say, hey, in civil court, they found that my rights were violated. Can you reinstate my parental rights? There's no avenue for them to have relief. So maybe being able to have like a jury trial system, I think maybe would be in the dependency system might be a little bit more fair, because I think jurors may be a little bit more fair than judges. Sorry if there's any judges in the room. Also, having some form of relief. So as an attorney, I've been able to represent parents in criminal cases. I've been able to represent individuals who suffer from mental illness and are in are considered gravely disabled or are in institutions. And I've been able to represent parents who've had their children taken. And one of the things that I'm always doing is comparing the different rights that those different groups have. In criminal court, if you are wrongfully convicted or there's a sentence that people think are just not just, we have presidential pardons, we have governor pardons, we have writs of habeas corpus that can be filed to say, hey, let's look at this case again, right? We also have that same thing true is for mental health. Someone who is, in a mental health facility has the right to say, hey, please look at my case again so I can get out of here, right? But when parental rights get terminated, there's no, relief. A parent doesn't get to go and say, hey, look at my case again. There's no avenue for that. So maybe having some form of relief, such as a 3A petition that a parent can file, right? And again, not in situations where maybe the child's already adopted, you don't want to disturb their stability, but at least maybe in a situation where there's a guardianship or something that's not as permanent. So those are my solutions. And that's pretty much my presentation. I'm glad that you guys all listened. I know it wasn't science-based, but it does require critical thinking.